Uh-oh.
Worked.
Hold on.
Well, while you're doing that, Suzanne, let me ask Jason and
Where's
Tom.
John?
Oh, you got him? You got it? You got it on?
I think so.
Okay. I'll ask you guys later, but I wanted some feedback on how Judge Mershon did in New York. And while you're doing that, Suzanne, let me ask Jason and Tom. Oh, you got him? You got it? You got it on?
You know what? It's doing double. I need
think
to.
so.
It's doing double.
Okay. I'll ask you guys later.
Okay.
Okay. We're good?
Yes.
Okay.
Now
All
you
right.
can talk about New York.
All right. So I'm gonna toss it over to you, Suzanne, to sort of give us a bird's eye view of this. And
This is a matter in a criminal case in district court, and it has to do with an offer of a plea and then taking the plea back, I guess. It's a defendant was facing a Class H felony drug charge, and the DA offered a deal if the defendant would plead guilty to a felony, and the DA said he would suggest probation. The defendant didn't want to be convicted of a felony. He wanted to go for a misdemeanor. And at that point, his defense counsel asked the DA for discovery, and the DA said, I don't have any obligation to give you discovery. If you want to get all this discovery, then I can tell you I am going to withdraw the plea offer, seek a conviction on the felony, and seek the maximum punishment. That's it in a nutshell. And the issue is whether, first of all, if the DA can make that plea, and second of all, if the defense attorney can accept the plea. Oh, there's Eddie. And I submitted a proposed opinion at the April meeting, and the proposed opinion stated that this was permissible as long for the DA, it was permissible for him to offer that plea if he was sure that he had fulfilled his obligations under Rule 3.8. And that's the rule, the special rule for prosecutors, and be like a two-step determination. The DA would have to be sure that the case is supported by probable cause, and then the DA also has to be sure that he has provided evidence that was negate or mitigate the defendant's guilt. So even though there's no right to discovery in district court, there's always a right to Brady type material. So if the DA feels confident that the case is supported by probable cause and that he's turned over any Brady materials, then he has the discretion to make this type of plea offer. The second question is whether the defense lawyer should participate in such a plea offer. And the proposed opinion states that as long as the defense attorney explains the conditions of the plea to the client, including the risk that there may be some exculpatory evidence in the undisclosed discovery, he can present the plea to his client. Presumably the client's going to know what might be out there, what he did or didn't do, and the defense counsel should follow his client's decision on whether to accept the plea offer or not.
all right. Well, I do recall when we made a first pass at this at the last meeting. I think I know what my position was on that I think that Suzanne has correctly stated both the law and the rules involved here. So let me start with you, Tara. What do you think needs to be added or subtracted or wordsmithed in this so far?
Well, I think based on my experience in my district, this entire practice shocked me. And because part of our H&I court, which I think is such a unique situation because it's carving out its own thing from since the legislation has been changed, We've had H&I court in our district since 2019. So, I mean, newer, but we've had it down a little bit. And when I've been reflecting on this and rereading it, Ms. Suzanne, I think your opinion is right, and I think the real issue is a legislative issue. But my main problem, when I think about the hypothetical, and I think about the role of the defense attorney, and so, for example, if you have somebody charged with sell and deliver cocaine, and it involves a confidential informant, and there's no requirement that the confidential informant's name be released prior to taking the plea. I feel like in these situations, if you condition a plea offer on, say, oh, I'm not going to look at discovery, I'm not going to ask for discovery. I think that in that situation, I mean, if the charge is that your client sold controlled substance to CI XYZ, I mean, your client can't not tell you what happened. It can't tell you if we don't know if the case is strong. We don't know who it is. We don't know if that is a known liar. We don't know anything about it. We don't know if that person's alive. And I understand that that does fall under the Brady umbrella, but it's hard for me to, wow, I think about it more from the defense counsel perspective, because in our district, our judge requires discovery before a felony plea can be taken in H&I court. And I think that it never occurred to me that people had H&I court without a discovery requirement, because I think that's the only way the process works. So that forced me to kind of reflect, go into the rules, see where exactly my problem is. And while I agree with Miss Suzanne, where I like the paragraph where you said, whether it's best practice, I understand that that's not the role of this committee. While it may offend me personally or offend I mean, I don't think that's right. I do agree that, it's not this committee's job to tell the prosecutor what best practice is. But from a defense attorney perspective, I think that in that situation, we're forcing the defense attorney to run into trouble with that, with 1.4b, a lawyer shall explain a matter to the extent reasonably necessary to permit the client to make an informed decision. And I think that in that situation, you're not making an informed decision, and there's no way for you to help your client make an informed decision. And that's the issue mentally that I'm running into, is if my client says, well, what do they have? In some of the comments and some of those rules, it says that, we're supposed to assess the facts and assess the law. And if it's a misdemeanor plea, I understand that kind of stuff happens all the time. Or maybe a lab results out there, and the DA and the defense counsel maybe decide to wait. Okay, we'll just go ahead and do it before the labs come back, whatever they say. But in situations where it's very, very fact specific, like the positioning of a gun in a car for firearm by a felon, or a confidential informant's involved, I think that we're putting defense attorneys in a particularly bad spot by telling them that they're supposed to, they're supposed to advise their clients when their hands are tied by getting plea. You say, hey, listen, we got a plea offer for suspended sentence, and if you don't take it, they're going for consecutive active sentences. Well, what are they saying I did? How strong is the case? Well, we can't ask for that. I can't tell you that, but good luck. I mean, I just have a problem with that, and I've had a hard time getting past that. So I think 1.4b, just going through it myself and trying to figure where my issue is, to me, that is where it is. So it's really that second inquiry, and maybe that's because that's my perspective. That's what I have a more difficult time with.
Okay, Jason, what you want to add to that?
I thought I think the wording that's proposed is very good. I think the admonition to the prosecutors is very good. But I think there's also, if you're looking at the hypothetical there, it was a possession with intent to sell and deliver, right? So I don't think there was anybody that there was a confidential informant involved. But there's other things that are that come in play. H&I court and district court, it's the idea of sometimes the prosecutor is going to give a better plea if they move the case quicker. And as in, like, the more work you make us do, the more work, then the worse it's going to get, right? So I don't think it's always this nefarious motive of trying to hide things, which is because, you know, a lot of times these cases are getting moved fairly quickly with where the prosecutor doesn't even have all the discovery. But the rules applying to the prosecutor about Brady materials and exculpatory materials are not done away by the discovery statutes, right? And I think in some senses too that if you are going to bring, say, a confidential informant involved, sometimes the state is going to say, "Hey, we're going to, in order to protect the confidential informant, we're going to give you this better deal." But if we have to expose them, which exposes them in a bunch of other cases too, then there's no reason for us to give this deal because now we've already burned this confidential informant. We can't use them anymore. It's going to be exposed to a bunch of other cases. So if we're going to go through that, then we're going for all the marbles, as they say. So I think there's a lot of that goes into that doesn't really implicate hiding evidence or trying to be unethical. But I think the truth of the matter is that in a lot of these cases, and it's noted in here, the defendant does know what they did or did not do. They have their own information based off of that. So if you can, and I think that to the extent necessary, the defense counsel can give a reasonably inform their client of what they're facing, what the evidence is, what the law is based off of that, and that they can make a decision that sometimes will be in their best interest, which is to take the plea without the discovery. But there's no obligation that they have to do it. It's just that, but the further you go along, usually the worse it's going to get when it comes to plea offers. But sometimes that's not the case. Sometimes as further you get into the case, some other evidence comes in or other things bring in, and you do get a better plea offer. But those are so fact specific. But as far I understand Mrs. Gore's passion, and I appreciate the way that she explained that, and I can tell she does a really good job for her clients. But for the specific answer and questions that we were given, I feel like the state bar's proposed opinion is very good, and I wouldn't change it at all.
All right. Tom, how about you?
Yeah, what struck me about this hypothetical in the discussion we had at the April meeting and with lawyers that I've talked to since then is that first this practice happens not only all over the state but all over the country. I mean, this is very routine. So we want to be careful if we're going to upset that. But the prosecutors I talked to, they're the ones that are like, "Oh yeah, I do that, but I don't really feel that good about it." I mean, there was something that felt a little dirty. And then the defense lawyers were saying, "Well, don't take that away from the prosecutors because that's how we get good deals." So there's that efficiency motive built in. I think what made some of the prosecutors I talked to uncomfortable is the threat. You know, all right, deal's off the table and we're going to seek the maximum punishment when you know you're really not. I mean, you kind of know what your case is worth. And the way I would have approached as a prosecutor would probably be like, "I'll offer you this today, but if we go to discovery, you know, all bets are off. This could be a little different down the road." You know, I think I support the opinion that Suzanne has drafted. I think as long as we're cognizant of Rule 3.8 and continuing obligation under Brady. Again, I don't like the threatening language. I would probably never approach it that way. But I think for the sake of efficiency and the fact that the defense lawyer has some of the best discovery around, he's got his client who knows exactly what he did and how bad this could actually get if you wait. And if law enforcement and prosecutors continue to dig.
Yep. Eddie, are you on the air yet? Is your microphone working? Doesn't look like it.
Just unmute.
He said no in the chat.
Yeah. Okay. Okay. Yeah, I see it. But you can hear us, can't you, Eddie? Yes. Great. Great.
You can type your comments.
Just from my perspective, there's a lot of things that are adjacent to this, like Brady, like Giglio, like the confidential informant. I have filed Roviero motions in my cases before where an informant was actually present at the scene of the crime, and his identity or her identity can be revealed if it goes to trial, so they can be cross-examined. But all of that is really adjacent to this opinion, and I can't tell you, I mean, I've practiced criminal defense for 40 plus years, and if I'm offered a misdemeanor on a serious felony like a sale and delivery, I'm going to do everything in my power to make sure that the client understands the consequences of turning that down. But all of that is practice related, and as Tom said, this kind of stuff happens all across the country. And prosecutors are, they're efficient when they close cases and they move cases. And so I don't see any rule violations, and that's kind of what we're looking for here, whether there's a direct rule of professional conduct violation. And I don't see any statutory violations either under 15A 901 and following, or the constitutional requirements of Brady and Giglio and so forth. And that's where the district attorney's office really needs to kind of dig in, and a lot of them do, and share. We have a Giglio lawyer that every time an officer takes the stand, any Giglio information for impeachment and cross-examination is given to the defense lawyer, and all, or really all, major prosecutorial districts across the country, they all have a conviction integrity unit that not only goes back and that goes back and looks and examines, and if things had not yet come to light that have somehow exonerated or mitigated prior defendant's case, they're pretty aggressive about revisiting that and correcting those errors. But that's, once again, practice related and adjacent. So the word threat is kind of a loaded word.
Is threat in the actual opinion?
Let's see, in the inquiry,
That is a loaded word.
I'm looking at the inquiry. The state indicates that there is no discovery requirement in district court. They will only provide full discovery if the client rejects the H felony plea offer, in which case they intend to move forward to trial in Class H felony and seek the maximum punishment available.
Yeah,
I think the word threat isn't actually in there, but we all read it as a threat.
Right. Right.
And I mean,
I wanted to make
you
sure
know,
that it wasn't actually in there, because I would want to address that if it was. But yeah, I mean, that's what it is.
right.
And I mean, I understand how lenient the plea offers, and I think for me that is the problem here too. That it feels wrong is if you want to say, listen, I have wide discretion and this is the offer I'm making, I don't think there's any problem at all with that. It's just if you don't ask for discovery. And I do understand a lot of times that might be for a larger reason, but also I do worry about getting too efficient. And I understand, like my CI example is outside the purview of this exact inquiry. I understand that too. It's just having been that defense counsel, and I know a lot of you have as well, I just worry that it comes back and bites defense counsel it's not an informed plea, but like you said, in this particular instance, your client would know more than anybody else. It's more how this expands into related issues that I worry about. But I think the opinion's well written. I understand your positions, and I certainly respect that. I think as far as the second inquiry and how it relates for the defense counsel, not so much as to the prosecutors, that's the part that I have trouble with. But I certainly understand your positions.
Well,
Is there more? Is
But
there more that we could put in there in the second inquiry and more of a duty on the,
I mean, it protects the defense counsel. So, I mean, I think that that is necessary. Let me see if I could read one more time. I think,
All right, we got Eddie on, at least we got eyes on
Hey.
Eddie. Now we got him talking, I think. Eddie, are you voice live?
no?
No, no. You might have to just communicate by sign language.
I was gonna say,
You know, Tara, to that point, I think that the opinion as written puts a duty on both sides. It
Yes,
puts a
sir.
duty on the prosecutor to make sure that 3.8 obligations that are, really above and beyond just Brady and Giglio.
Mhm.
But it puts a duty on the prosecutor to perform professionally and ethically.
Mhm.
And it also puts a duty on the defense attorney to likewise, to the extent possible, make the client informed about everything about the case, what they know and what they don't know.
Mhm.
And that can only go so far. I think when I said in the April meeting, it's really kind of ironic to seek informed consent when you don't have any information.
Right, and
And that's
that's
kind of
kind
an
of,
oxymoron in a
I
way.
think that's where I am on
Yeah,
this at the
yeah.
root of it. So I don't know what language I would add. It's just that I have trouble with the help them make informed decisions part because I feel like in my brain when I look through, then the answer to the opinion would be no, because I can't help them make an informed decision. But if that is stretching it too far, like I said, I certainly appreciate the perspective of you all as well.
but I think part of the information that you give your client is that you don't have all the information
Right.
Well, true.
and that you're taking the risk. I mean, that's what you have to explain to the client.
Sure. I think all this is making me feel very lucky to live in the district.
All
That
right. Tom, you
That's what
got your
I'm
hand
saying.
up. You got
Yeah,
your hand up.
the context that I saw this in when I was a prosecutor was in sex crimes, particularly those involving children. You might have the family come in district court or early setting in superior court, and they want to be done with this. And they're saying, indecent liberties, or did I get knocked off?
No,
Yeah. Oh, indecent liberties or sexual battery and be done with it. But if she has to go to another forensic interview and we have to turn over all these statements so that this offender can read about this sexual act, we don't want, after that, we don't want any deals, is what the family will tell you. So in those, that's a case I usually would wheel and deal like that as the prosecutor. I mean, we can deal with this today, indecent liberties, probation, sex offender registration, or yeah, he can see everything and we can go to
Right.
trial.
I also think that we have to remember too that even in the H&I pleas, the district court judge has to go through the full transcript, and part of that is a factual basis, and the judge cannot accept the plea unless he's given us or she is given a sufficient factual basis that gives them enough information that they can accept the plea. And then at the same time, at that point, the defense has a right to object, add to, or detract from. I think there's some other safeguards that are put into place there. And some things I think are still a matter of public record, right? I mean, like if you go get the incident report from uh, or the Bear incident report, at least the front page of it from the law enforcement, if they're charged like they would have been in this case with possession with intent to sell and deliver. So I don't think it's a place where you come from where there's no information whatsoever. It's just limited. It's not the same amount that you'll get if you go through a full discovery process. And every person in here that's tried a case knows that it's really information is all coming all the way back up all the way usually until the actual jury trial starts, sometimes afterwards. And so there's always a limitation on that to a certain degree where you have to not believe, but that trust that the different officers of the court involved are following their obligations. But I do understand Tara's point of view, and I agree wholeheartedly with what Tom is saying based off of my prior experiences being a prosecutor, that some of those other implications come into play. And I think usually the defense attorney knows that. It's discussed with them that this is why we're doing it. And then they have the chance and opportunity to inform their client of, hey, this is why they're giving you the deal, not because they think you deserve it, but they don't want to put the family through this whole thing. And they're willing to make this deal because to prevent the family from going through that. And the defendant may think, well, I'm willing to take that deal rather than get more information because I don't want to lose it later, especially considering that they know to a certain degree what the level of their guilt is, better than the other parties or the other officers or anyone else knows. So that's just my 2 cents.
Yeah, and I agree with Tom. In my experience, the longer the case goes on, actually, the worse it gets for the defendant. And the more information comes into the prosecutor's office, both either federal or state level, and it does tend to aggravate the situation almost invariably, and thus I see the implied threat there, not the explicit threat, but to seek the maximum possible sentence is just a statement of fact. But that doesn't give me much heartburn myself. All right.
Well, I mean, this is going on, I think, already, right? I mean, this
Yes.
is, I guess, not in Tara's district, luckily, but it seems like it's somewhat common practice that's.
And I do think that comes back to it being a legislative issue. I think H&I court, misdemeanor pleas, that doesn't bother me at all. There's less ramifications, but felony pleas without discovery is kind of where my heartburn was on this. But I think that what it comes down to is H&I court hadn't been contemplated at the time. There's just the discovery statutes don't necessarily line up with H&I court. And if there's a way to fix it, I do understand that it's probably outside the purview. I do not want to be the defense counsel in that position. And that is kind of how I read these facts.
But I think that's the reason why it's H&I court, right? They don't let you do G's and above in district court, and they're trying to keep, I guess, be more efficient by allowing that to happen in district court. But going back to the whole ramification thing, I think that is kind of implicated by the fact that they don't allow anything higher than an H to be done in H&I court, which is kind of going to the idea of, well, I don't have as much heartburn when it's a misdemeanor. Even though the defendant still has all the same rights in a misdemeanor, and the defense counsel still has all the same obligations, and the prosecutor does too, even in its misdemeanor. I think
Sure.
So
Yeah, Tom, you got your hand up.
No, I don't.
There's less at stake as far as what the defendant is sacrificing. There's so many things that come with that label of a felon, and that's kind of.
I agree with you on that.
All right. Well, have we beat this enough, or
I think we have.
do I hear a motion?
Motion.
A second?
Second.
All right. All in favor, say aye.
Aye.
All right.
What is the motion?
I don't know what we're doing.
Sorry, to accept the as written, the proposed opinion.
We're going to present it to the.
And to present it to the whole ethics committee.
Yeah, for publication.
Suggest. Who knows what we'll get from that?
Yeah, well, we'll get some fallout from that, but yeah, I think it'd be good to publish and see what the comments are. So one final housekeeping matter. I'm not going to be at the July meeting. I'm going to be up at Lake Champlain in Vermont and Lake Placid during that time. So Tara, would you take over as chair and
Sure.
sort of present this to the full ethics committee for all of us? And then
Absolutely.
I'm sure, and then call on the other members to weigh in.
I was going to say, as long as I'll have some backup, I'm
Yeah,
happy
well,
to
and give
step in.
Eddie a chance to speak out loud. So he can put,
Listen, I apologize for my issues.
oh,
I don't know what
Oh,
happened
can you hear
today. I had to get IT involved. It was weird. But I will say, you know, I'm glad I was able to at least hear what was going on. You know, when we were first presented this this topic, I felt the same way then that I did now in terms of, you know, I hate it, but I think this is more of a legislative issue. And then Tara made me feel like I was a bad public defender because I was like, oh, and should I be fighting more? It just sounds like am I not doing enough? But I'm glad that at least I was glad to hear that she's like, oh no, yeah, this is a legislative issue. So I'm glad that we're all, at least I'm not about to be disbarred for being a bad public defender. So that's the great outcome for this meeting.
I think also apparently it goes back to we've got 100 different counties and 100 different way of doing things. So, you know, if for us, there is a discovery requirement, but it's imposed by the judge rather than by, you know, anything in the statute.
yeah.
And
You know,
I
in
think-
Mecklenburg, we were lucky because Peter Gilchrist started open file discovery back in the 80s before, you know, 15A 901 and following was passed. So we had full file discovery, you know, 30 years ago, 40 years ago. So, I think Cole and Willoughby did the same thing in Raleigh too, I think, Suzanne, but those two were really trailblazers for the district attorneys. All right.
Okay.
We're
Thank you
done.
so much.
All right.
Thank you guys. And thank you, Ms. Suzanne, for your writing this.
Yeah.
Oh,
Thanks,
Excellent
Suzanne.
job.
Thank you, guys. Thanks for everything.
Okay. Take
See you in
care.
Beaufort.
See you.
Enjoy Vermont.
I will. I tell you, I will. Take care.